lecture number 9. This is the last week that we are going to meet. And I suppose by now you should have enough information on the essential parts leading to a grant. And in this lecture, we shall talk about the more comprehensive part on local grant priority in terms of testate as well as interstate. And then we shall move on to the Hong Kong grant application in respect of foreign domicile. So in other words, if you can still recall, this grant concept, on the one hand, depends a lot on testate or intestate, the contents of the will in terms of testacy, and then the rule of intestacy in case of deceased died without the will. But all in all, you need to ask yourself this question, what exactly was the domicile of a deceased at the date of his death? So if you can sort of ascertain this position, generally you will be given a guideline as to how to go about having a grant. Towards the end of this lecture, we shall examine the checklist, several pages. By then, we shall turn on your iPhone or your notebook in order to look at the checklist. If you have the notebook with you, then you can have a better view as opposed to what is to be shown in the PowerPoint, because we'll be showing 2 pages in each slide, whereas in your notebook, if you go online, you should be able to see 1 page at a time. And it would be a very useful tool for you to comment on the various problems faced with grant application in this whole module, if you are able to understand the various questions stated in the checklist. So these are things that would reinforce our understanding, and then it will be an easy task for you to handle the grant application in Hong Kong. Now, last time we talked about the Hong Kong grant priority. The first is the general rule. So that would be Hong Kong domicile, testate, Rule 19, and then Hong Kong domicile, intestate, Rule 21. So that will be the first of the 3 components that you're expected to discuss in order to give a thorough picture on the grant priority discussion. So that was done last time. And then this is the second component of the same problem in terms of priority for grant application. So this is priority B, so to speak. And this is parties variation. The first type is by way of voluntary renunciation. And the second type is construct. Sorry, would you please do amend this? There's a typo here. It's constructive renunciation. Number 2, CONSTRUCTIVE, constructive renunciation, not construction, constructive renunciation. That deals with involuntary variation. So this is the second level, and we term it priority, the B components. On voluntary variation, in principle, there are two ways. The first way is by way of oral renunciation during a probate action. This kind of oral renunciation is rather rare. It's rather rare. So in order to make use of this oral renunciation in court, it has to be a probate action, and then counsel, or if you act in person, you can address the court and tell the judge that, all right, I want to step down. I don't want to apply for a grant, even though I am the person with the highest priority. So if the court or if the judge accepts that, that can be taken as an oral renunciation. The more common type is written renunciation. Now, written renunciation is something to be done in writing by following the specified form. By following the specified form. The present specified form is the update one. So the written renunciation is now, by following the form, to be executed by way of deed. This is a correction or an improvement. In the past, or even now, in the provision, in the law, it only talk about written renunciation, trying to make a comparison between oral and written. But the true way is more than something in writing. It has to be by deed, because this is something to be done without consideration. So something by deed does not require any consideration, and therefore the present specified form perhaps has answered this uneasy question, and the matter is considered as settled. So by way of deed, written renunciation. So this is priority B1. B1, either oral renunciation, or B1, written renunciation by deed. The thing to remember, the practices, one requires to renounce all positions, all priority. So for instance, well, I think this appears more often in a testate situation. So the mother make a will, appointing the son as the executor and trustee of the will. And in the will, the mother gives everything to the son and the daughter in equal shares. So in this simple example, we have the testator, which is the mother. We have the executor, we also have the residuary estate trustee. We also have the residuary beneficiaries of the son and the daughter. So in order that there are renunciation properly done, this will have to be done by the son in renouncing all his possession, meaning prior position, prior priority. In this simple example, the son occupies 3 capacities. One is the executor, which is first priority under Rule 19. Second, residuary estate as trustee, then this is second priority. And then ultimate residuary estate beneficiary, which is much lower. In that it is much lower, it is in that sense having equal priority with the daughter, meaning both the son and the daughter are in the same bottom line priority as ultimate residuary estate beneficiary. So in order to deal with this voluntary variation by the son needs to resign or renounce 1, executor, 2, residuary estate trustee. He doesn't have to renounce as a residuary estate beneficiary, the ultimate residuary beneficiary. No need. But then the law simply says that, okay, I now renounce, as you can see at the bottom of this PowerPoint, renounce all my rights